I'd like to invite our three presenters up here to the table, and then I'll be calling on people for a question and answer period. So we'll give them a moment to settle down.
So since I never managed to get my notes open when I was speaking to you, I naturally forgot a couple things I wanted to say. Two important things to bear in mind about Federal Energy Regulatory Commission jurisdictional pipelines. One is, once the Certificate of Public Convenience and Necessity is granted, the pipeline has the power of eminent domain. So there is some incentive to negotiate with landowners in advance just to save themselves the trouble of going to court. But they do eventually have the power to seize the property, whether the landowner wants it or not. And in the Mark I case, for example, they told the Federal Energy Regulatory Commission they were negotiating with landowners, so it would be in the public interest and it wouldn't have much of an impact. And the day after they got their certificate, they condemned more than half the properties. The second thing is that federal law preempts, which means that although FERC does prefer and will encourage the companies to comply with negotiated plans for mitigating the impacts of the pipeline, if the company and the agencies cannot come to agreement, FERC can override it. And we did see situations in the Mark I case, for example, where the pipeline company was writing threatening letters to the Pennsylvania Game Commission for taking too long to review the project and approve proposed mitigation measures, and threatening simply to disregard whatever they were going to say because they were holding up the process. So there is a great deal of power in that federal commission to override both the state and the federal and the localities if they don't come to an agreement. And you should just be aware of that as you're planning for your localities, that you do not necessarily, in the end, even with your zoning, control exactly what's going to be happening with a federal pipeline.
Can I just add to that the state law does not confer property rights. Nothing about Article 7 conveys any property rights at all. So it's different from the federal process.
Yeah.
What I'm trying to say.
Which is not to say that the pipeline companies don't have the power of eminent domain. They just have it separately from Article 7.
Okay, and I'm going to call on people, and we're going to have a microphone go around. So our first question is over here with the microphone. Carolyn will be second.
Just a question for Jim Austin. Is your department aware of the physical limitations of the steel and epoxy, what the life cycle is of that and the lifespan?
Absolutely. Our orders specify a certain type of coated steel, and the allowable pressure that the line is allowed to be operated is based on those requirements. So we not only know where it is, we know what it is. We frequently require some type of cathodic protection on top of the epoxy coating. So yes, we're absolutely very aware of the engineering principles of the steel used.
How long is it?
I'm sorry?
How long is the life cycle?
Well maintained. The process they use to inspect a pipeline is called pigging. It's basically a little robot you stick in the pipe, and well maintained. An epoxy coated line with cathodic protection, we've gone through 30 years later and seen no corrosion at all. So, there are pipelines that have failed, as was mentioned, but thankfully they're very few and far between.
I'm not sure who the question is for. Can any of you comment on at what point in the process for the companies of assembling the rights to the various parcels or right-of-ways across those parcels do these applications tend to come? Have the companies typically assembled some percentage of rights ahead of applying for the right-of-way? Are they just looking to overcome last holdouts, or how much notice does a community tend to have because of that negotiation?
Well, I can speak to the state process, and perhaps you can speak to the federal. typically what happens is, I said, Article 7 doesn't convey property rights. So the developer and the landowners have to come to an agreement. And typically, I'd say very frequently on the smaller lines, they come in with 100% control before they file an application. Never do we allow them to build anything obviously without 100% control. But usually it's 80% or higher, and normally the few remaining parcels of land are under negotiation or very close to being finalized before they even submit an application. So the application also has to be served on all, well, obviously the landowners know about it, but any local government that a project goes through, the application has to be served on those entities.
Another major difference and improvement in New York versus the federal system is that in the application process for a gathering line under the Department of Public Service, part of that application is going to be a list of the landowners whose property is traversed by the right-of-way. And it will also give you the status of the negotiations. So you can see exactly who's going to be affected and whether or not they've already negotiated a deal or not. In the federal system, that's all privileged information. And so everybody is operating in isolation from each other, and nobody knows, you may not know at all, whether your neighbor is negotiating with the pipeline company or not, or who's going to be in the right-of-way or what the route's going to be. Until you actually get the application with the map. And even then, you don't have access to the landowner information.
I have a question for Mr. Austin having to do with your reference to noise and the Department of Public Service. Could you talk about the jurisdiction and or elaborate on what you meant by noise? I'm speaking specifically, for example, about gas transmission,
Well, really, there's two elements.
compressor stations, I'm sorry.
I was going to say there's two elements. One is during construction, and the second is during operation. If the pipeline doesn't have a compressor station, there's no noise impacts generally. We require one of two standards for noise. One is either what the municipal government requires, and our fallback position, quite often municipal governments don't have standards in their code for noise impacts. Some do, some don't. If they don't, we require 40 dB at the nearest receptor, and that's under the most quiet conditions. And I will tell you, there's been many cases where we were promised 40 dB. One of my guys went out with a sound meter and didn't get 40 dB, and we required them to either build a better building around the compressor or install muffling or a combination of the above. So we do very strictly enforce that requirement.
I have a quick follow-up. It's a yes/no. Is it so that the Public Service Commission is going to be regulating or will consider regulating pipelines under 125 psi?
Well, I can't answer that yes or no. I'm sorry. The threshold that I described before is set in state law. So my department has no statutory authority. If the legislature were to change that threshold in state law, then we would.
This is a question for Jim. What is your capacity for inspecting these pipelines? I mean, how many people are in your department or overall, and how often do they inspect, and do they inspect the whole length of the pipeline?
Well, again, there's two answers to that. One is during construction, and one is during after construction during operation. My office, the Office of Energy Efficiency and Environment, has a certification and compliance unit. We're responsible for pre-construction and construction. And my office is about 40 people. Not all of them are doing pipelines at any given time. We also do renewable energy. We do energy efficiency. So those are the other things in my office. Post-construction, we have an Office of Electric, Gas, and Water that has a section called Gas Safety. It's actually just safety. And they have a pretty substantial staff. And I'm not from that office, so don't hold me to this, but it's my understanding that they have to do each line at least once a year. Now, you have to understand these lines are buried. So, going over the right-of-way to make sure there's no trees growing into the tree roots, growing into the pipeline, isn't the same as pigging. Pigging is generally a once every 5-year proposition, but as far as reviewing records for how much gas is transferred, what the operating pressure is, what the moisture content, and that could be a really big deal, how much water is in the gas, that's a regular occurrence. They do it all the time. And that's, again, my counterpart office, the Office of Electric, Gas, and Water. Does that answer your question? Or?
You're next, after this one.
I wanted to get a clarification from the first speaker. The hazardous liquid pipelines are liquefied natural gas, crude oil, and the other one was liquid propane gas, or there's 3 kinds of hazardous liquid pipelines, and I didn't get them all down.
The ones that were listed are ethanol and other biofuels, liquefied natural gas, liquefied petroleum gas, and crude oil.
Liquefied petroleum gas and crude oil. Okay. Okay, thank you.
I'm not sure who this is for. We're talking here about fairly major transmission lines. One of the things that concerns people in terms of shale gas development is the proliferation of many wells, many well pads. And it's not clear to me what we're talking about in terms of lines that will go from each well pad. Obviously, every well, you have to get the gas somewhere. And who regulates how those individual lines get sited by who has to give permission for those, what kind of environmental review, particularly whether there's any cumulative impact review of that before they get to these big major lines.
I'll take a shot, and then if you want to jump in. Generally, we have gathering lines, midstream lines, and transmission lines. You're referring to the gathering section. Anything above 125 psi or 1,000 feet is subject to our jurisdiction. Wells in the Marcellus tend to be very high pressure, at least that's the experience in Pennsylvania. Some around 1,400 psi, I mean very high pressure for wellhead pressure. So they're going to be above that 124 psi I was talking about before. New York State also has a minimum siting requirement for well spacing. They have to be about a mile apart. You can't put wells closer than a mile apart. So they're going to be greater than 1,000 feet as well, the gathering line. So that's also going to trip Article 7. Probably the lower threshold, the 121A2. Marcellus hasn't started in New York. The last big play in New York was Trenton Black River. I will tell you that when we did Trenton Black River, when the companies came in, we asked them to come in with their whole development plan. Now, the reason for that is exactly what you're talking about. We don't want just line. We want to do some planning. Now, the companies tend to hold that information very closely because it's basically their competitive advantage. So they will ask for and we will grant business confidential status to that data. But we don't want them, for their benefit, for ours, and for, frankly, the impact on the environment, we don't want them to come in piecemeal. We want them to come in with the whole thing. It takes us, one thing I didn't mention before is the law requires I process a small application in 30 days. And if I don't process it in 30 days, the law says it's deemed approved as submitted. The medium is 60 days. And then the upper one has no limit. I can extend the 30 days to 60 days once, and I can stop the clock on the 60-day one, the medium one. If the commission has to take an action saying that we need a hearing, and that stops the clock. But for the most part, 30 days after I get a complete application on these small lines, I have to approve it, or it's deemed approved. And you can imagine we generally want more conditions in the permit than the applicant does. So as a result of that, it's to their benefit to come in with a complete application and to come in with as much information as possible. Because if we can't approve it, we'll deny it. rather than just have it deemed approved, do you see what I'm saying? So it's definitely to their benefit to come in with their development plan.
And I think I just want to add, and you mentioned it, I just want to emphasize that there's a lot of partnering agencies that if it goes through an ag district, if it goes through wetlands, the Army Corps was mentioned, they're automatically involved in the review as well. And they don't have authority, but they're very instrumental.
If DEC or Ag and Markets wants a condition in a permit, 99.9% of the time the commission does it.
Yeah.
There's a few circumstances where it doesn't happen.
Yeah. And they have a lot of regulatory guidelines and concerns with pipelines that are pretty well thought out, so I thought they were. Yeah.
One thing to be aware of here in New York is that although typically what's happened in other places is the wells go in wherever they want them to go in, and then the pipelines get connected later, there is the possibility here that the pipelines will go in first. And the idea is to be able to facilitate what's known as green completions, so that when the well is developed, there's a pipeline ready for it to tap into, so you're not venting it into the atmosphere, you're not flaring it, you're not creating all of the pollution that comes from those processes, either the kind of pollution that causes asthma or climate pollution. So that is a very different approach than is standard, and it would give people a lot more advance notice of where the wells are likely to be. It would allow for some planning. It is something that DEC did mention as a possibility in the supplemental GEIS, but we aren't sure whether or not it's actually going to do it. There are now new federal regulations that are going to require the companies to move toward green completions, but they've got until about 2015 to do that. So it could be that here in New York, since we are in a position to actually do some planning and prepare for this and reduce the impacts, that we won't get the sort of helter-skelter well development that we've seen in other places. And obviously, there are many people who would prefer to see none, but if there's going to be any, it would be much better to have as much planning for it as possible, both because that means you're in a better position to site things in less environmentally sensitive or places where there are few people at risk, and also just because you're going to give people an opportunity to prepare and adjust in advance. Federal pipelines are, this is not an issue. The federal pipelines are not the pipelines that go from the wells to the gas. They have no oversight over those.
In a good example state, I believe Colorado is experimenting now and doing a statewide regulation for green completion, so it's a place to research.
Can I just jump in real quick? Before I talked about the commission has to find need for the pipeline, historically, need has always been a completed successful well. A green completion means that we have to have the pipeline before you have a drilled successful well, and you have to risk the environmental impact of the pipeline before knowing whether or not the well is successful. We're struggling with this. What EPA's rule says is that if you know that the well is in a fairway where there's been a very high success rate, that you do require the green completion there. What we're thinking about is maybe, as the EPA reg does, maybe an exemption for what's called exploratory or delineatory wells, what delineates the boundary of the fairway. We've never done this with the commission before, and I can't predict how the commission's going to react because they have to find need. So we're still working on it.
Right. I mean, one big challenge I think for many of us is to try and get need defined differently, and have need relate more to our actual energy needs, the needs of people for a healthy environment, and so forth. But at the present time in the federal system, all of those things are supposedly taken into account as part of the public interest determination, but they're routinely overruled by the fact that somebody's going to make a profit.
Let's go on to the next question.
Yeah, my name is Mike Coles. I'm a real estate appraiser, so I was particularly interested in at what threshold do these companies have eminent domain at the federal level or the state level for the different size pipelines we have, or do they automatically have eminent domain?
With a federal system, anything that's federally regulated gets eminent domain. That means compressor station sites, that means pipeline sites. If it's under FERC jurisdiction, when you get that certificate, what it means is you now have the right you have eminent domain in order to build your pipeline and the right to construct the pipeline and operate it.
It's a little different on the state level. Eminent domain is granted to what's called a Federal Transportation Corporation, and many of these pipeline companies are, okay? Having said that, nothing in Article 7 conveys property rights. You have to work it out with the landowner. If the company is a Federal Transportation Corporation and the commission grants a certificate of public convenience and necessity, that's in the eminent domain portion. Let's say you go to eminent domain, there's two segments. The first is the need, and the second is the value, okay? The act of the Public Service Commission settles the need part of it. You then have to go to a judge an eminent domain proceeding to settle the value. What's the taking worth? I will say I don't know of a single case in Article 7 where eminent domain's been used. I've been doing this for 30 years.
Yeah. Well, and there's a very good reason for that, because why on earth would a landlord why would you go into eminent domain once you knew you were going to lose? So if you have a Federal Transportation Corporation that's got the right of eminent domain, and you know that they've got a public need determination already, and it's only about value, then at that point, you negotiate.
Not all pipeline companies are transportation companies,
right.
Just so you know.
I have one question for Megan. I thought your presentation was great, okay? And I don't want to put you on the spot, but they are building the new Corning Hospital right on a 70-acre property that has a 36-inch...
It has a lot of issues. There's even wetland
issues. Did you have any input on that one?
I wasn't the planner involved. We did have a planner within STC that is the municipal planner for the community, and she has so much, she can only put out so much demands or suggestions for the community to consider, but there's a lot of other parties. I know that the Soil Water Conservation District is involved, and they were involved a little bit later in the process. I know that there was certain approvals at the community level that were approved, but there were certain state reviews and permits from DEC still on hold, and they're sorting it out. So I know. Hopefully, all the parties are talking to each other now and working things out. But there is the particular location of the hospital has issues.
As a local government official, I wanted to ask if I heard something correctly. I thought I heard it said that the Public Service Commission will handle all of the gas line regulation, and that in effect, local government only has control over noise and I assume road cuts. Did I hear that correctly?
Yes and no. Article 7 supersedes well, no, it doesn't supersede it. It says that the applicant can suggest that a local law is unnecessarily restrictive. So if there is any law, normally what happens is the applicant comes in and they say that all the local laws are fine, we're going to adhere to them all. Occasionally they come in and say, well, we think we can't build it because of this, and then they have to demonstrate why it's unnecessarily restrictive. So if you have a noise ordinance, we defer to that. If you don't have one, we use our own. But that applies to any local ordinance. That the company has to say either we're going to comply with it or we find it unnecessarily restrictive. And if they find it unnecessarily restrictive, they have to convince the commission that it is. Okay, so the commission does have the power to supersede local ordinance, and you can't require any substantive permit or requirement, but for something like a road crossing, the town owns that road, so that's a property right. So you can require that they get approval for you to cross your property. Did you see the distinction? So any road crossing, generally, we require either the state DOT or the local government to sign off, is what it comes down to.
How often do you supersede local laws?
It's fairly rare, especially in pipelines. And it's not me, it's the commission. It does, I'm not going to say it doesn't happen. Normally what you see is a zoning requirement. Some towns, wind is a big one, ban wind right just outright. That's never been superseded, but developers have said that's unnecessarily restrictive. So I'm not going to say it doesn't happen, but it's actually pretty rare, and the developer has to make a very, very good case that it's unnecessarily restrictive. It's not just automatic, is what I'm saying.
Okay, next question.
Deborah, this is a question I think mostly for you, but maybe the other two can weigh in on this. The laser gathering line, I sense, was somewhat controversial in how it was named and therefore regulated as a gathering line and not a transmission line. And I'm wondering if you can comment more on that, whether it was a case of, you consider it a case of segmentation, and also if there are any lessons that we can learn from the way that was set up, and how that might carry through if there are additional gathering / transmission lines that are put in place in New York State.
You know, I think people were very surprised that a pipeline that crosses the border was not deemed to be something that was subject to federal control as an interstate pipeline. I'm not sure in the end it was necessarily a bad thing that it was regulated at the state level. Honestly, given what I've seen from the Department of Public Service versus what I've seen from FERC, you probably were better off having it regulated in New York under the New York State, from the New York states. Now, in Pennsylvania, it's a completely different system. And in Pennsylvania, the gathering lines are not regulated as by their Public Utility Commission. There's no siting control, none. The pipeline goes in, it gets its right away from the private property owner, and it may need to get some stream crossing permits, but otherwise it goes wherever it can buy a right away. And so there's no cumulative review, there's no land use control. They've just passed a law that strips the municipalities of all of their land use control, basically, anything related to the gas development. So, here in New York, I think that you may very well have done better. In Pennsylvania, if it were a gathering system that could have been subject to some environmental review, it would have probably been better off. And the segmentation issue is an interesting issue. For those of you who don't know what segmentation is, it's typically what happens is you have a big project that if you were going to do an environmental review, it plainly would have a significant impact. So you break it up into a bunch of smaller projects, none of which individually have a significant impact, and you then decide that it doesn't need to have an environmental impact statement. And there is litigation right now, actually, that's just recently been commenced about the Millennium Pipeline, arguing that there's segmentation going on. I think that there's a segmentation claim with respect to the Tennessee gas pipeline that's going through Pennsylvania, and I think there's potentially other segmentation claims, because what we are seeing is the companies come in with this piece that gets an environmental assessment, then they get the next one that connects to it, it gets an environmental assessment, the next piece gets an environmental assessment. If they'd done the whole thing, it would have been a major federal transmission pipeline subject to an environmental impact statement. But of course, you don't know that till you get down the line some way. And because they can hold a lot of this information as proprietary information, it's very difficult for the public to get it all until it's publicly announced. But I don't think that there's necessarily a hard and fast rule that by going to state regulation here in New York, you're going to do worse.
May I just add, in the case of Laser, they petitioned FERC to ask whether or not it was a gathering line or an interstate line. They actually wrote FERC and said, we'd like you to tell us. And FERC declared that it was a gathering line, therefore subject to individual state jurisdiction in each, above and below the border.
Okay. I would describe it a little bit differently. I would say they put in a petition with all the information they needed to get out from under FERC, and then they get out from under FERC. But the outcome was the same.
Just saying FERC decided, that's all.
FERC did decide.
Yeah, I had a question about the gathering lines or the pipelines that are under 125 PSI, and they seem to escape careful scrutiny during construction. But sometimes we see that these pipes are built and they're able to handle much higher pressures by magnitudes of order. So the question then is, are there cases where the line is then changed from one under PSI 125 and then graduates to the one that would have had scrutiny? And if that does occur, how does that affect impacts on setbacks? For example, I gather schools, pardon me using the word gather too frequently, but if schools, isn't there a setback requirement for schools on certain of these lines, or hospitals where one has to deal with maybe emergency evacuation of very difficult situations?
Well, I could write a book on this one. The first part of your question. Yes, lines that operate under 125 PSI are frequently built to pressure to engineering specifications that would allow them to operate at a higher pressure, okay? As I said, it's not my office, but the Office of Electric, Gas, and Water has a gas safety unit that monitors on a very frequent basis the actual operating pressure of the line, among other things, water, throughput, things like that. If they were to operate at 125 PSI or above, we'd be all over them. And I can think of one company that we were recently. If they wanted to come back in and say, well, we built this line to 500, but we're operating at 124, we want to operate, greater than that. Earlier I spoke about that rebuttable presumption. They have to demonstrate to the Commission's satisfaction that they didn't do it to escape our oversight. And that's a pretty tough presumption to rebut.
Sure.
So I'm not going to say it doesn't happen. As I said, I can think of one company that has come in and said we'd like to operate at a greater pressure, and they didn't get very far. As far as the setback, I can't speak to that. I don't do design. I will tell you that the right-of-ways are very carefully scrutinized for what they're next to, and the operating pressure would come into that. And our gas safety people are part of that. I'm just not a design engineer, so I don't want to misspeak.
I see. And just finally, if I could, I know there are ghost wells that we are aware of in New York State, some 30,000 of them or something, even more than that. Are there ever such things as ghost pipelines, the ones that escape scrutiny and then years later?
Certainly anything that's Article 7, we know where it is. And frankly, the gas safety unit knows where the stuff below that threshold is. If a company wants to shut it down, they have to come in with a remediation plan. Frequently, the pipelines aren't dug up because it would be more of an environmental impact to dig them up. But they are purged, and then usually an inert gas or something else is used to purge it. And once that's done, the pipeline remains in place.
There's a federal government agency that's been mentioned before, the Pipeline and Hazardous Material Safety Administration, PHMSA, which actually is the one that regulates. It's in the Department of Transportation. This is a transportation of gas, so it's in the, believe it or not, the gas transmission line safety is in the Department of Transportation, and they are the ones who regulate safety. There are no setbacks that I know of. There are different standards for design and construction and operation depending upon the population surrounding your pipeline. So, for example, you can build right near a hospital, you can build right near a school, but if you are within a certain distance of a certain number of people, then you're going to need to build to a different standard. There's different classes of pipeline, different areas, and a pipeline that was in a very low population area, and there's a high population that moves close to it, could potentially be asked to upgrade their pipes, for example, in the segment that would actually be near that population. If it's foreseeable, presumably they're going to want to build that from the start. If they're in what's known as a high consequence area, where you have a bunch of people who are potentially in that impact zone, that circle you saw, then there could be higher standards there as well. But there's nothing that would prevent anybody from locating a school or a hospital or a nursing home within the impact zone.
Yeah, I think the problem is over time it gets more lax. And if the pipeline was there for 30 years and it was egg land, and then all of a sudden finally development comes by it, it's hard. I mean, the operators don't do their job in informing the property owners, and things don't get communicated.
And part of the problem is, I mean, we saw those lovely maps that Karen did for us, but those are transmission lines for the most part. Here in New York, it's a little bit easier to get information about the gathering lines because, again, the Department of Public Service is much more transparent. In Pennsylvania, the only way we could get information about the location of gathering lines was to go to the Pennsylvania Bulletin, which is the it's sort of like our environmental notice bulletin. It publishes notices of the various different permits, get stream crossing permit applications, and connect the dots between each stream crossing permit, and hope that we were more or less getting the trajectory of the gas pipeline. Mm-hmm. But we had no idea, if there wasn't a stream there, we had no idea where it started, where it ended. We did, and if there were lots of them, we didn't know whether, which direction it would go. And all that information is being held because in the national security. Okay.
And it's tough because for a planner, you want to do comprehensive planning and future growth, and it's hard to do that if you don't know what's underground.
Right. The only county I know of in Pennsylvania that actually knows where its gathering lines are is Bradford County.
Yeah, they have them all online.
Yes, and they've mapped all of their gas resource activities, and so you can see where the pipelines are, you can see where the wells are, you can see where the impoundments are, where the wastewater treatment plants are. You should take a look at the Bradford County Planning Commission map sometimes if you want to take a look at what a fast build out in a county looks like.
And we're getting close to the end of our time, so I'd like to find out if there's any municipal officials who have not yet had a chance to ask a question, or again, a planning board member, or someone who is with local government.
So I appreciated the hearing that the PSC would actually try and get a comprehensive review of all of the transmission lines that a given company intended. But there's multiple companies. So how do you contend with that?
Where do I go with that? We have, Laser was recently completed. We have another project that runs from basically the same place, ends the same place, parallel 8 miles apart.
So there's nothing to compel them to collaborate and
well, the commission, these are competitors.
Yeah.
The commission does have the right in saying there's a need for this project to say there's a pipeline right there, use that one, and then they'd have to negotiate between themselves. As I said, the commission does have to find need, and 2 pipelines in exactly the same spot, they're going to be hard pressed to do that. But the well drillers are different companies. The gathering and the midstream companies are all different companies. So
we're really looking at a total spider web of.
I think in general a lot of people are concerned about natural gas development, and we're all focused on the rigs and the pads, but really the pipelines are the more long-term impacts that we should really be worried about.
Yeah. From a surface impact perspective, I mean, you should take a look, if you haven't, at the Allegheny National Forest aerial photos to see what this looks like. I mean, it really looks like a spider web.
Yeah.
And particularly in areas in New York State where there's forested land, they typically, the permanent right-of-way we heard is about 50 feet, but they can clear as much as 150 feet during the construction. And they typically don't replant trees. What they do is they just, they'll plant grass cover, and they'll allow everything except that 50-foot right-of-way to revegetate naturally. So if your deer aren't eating your seedlings, you might get forest again. But you could end up with a very wide swath of permanent right-of-way, not just temporary right-of-way. And of course, it makes a huge difference for your water quality, for your watershed, for your wildlife, for greenhouse gas absorption, because you're losing so many trees. So, one of the things that, that would be great if the localities would think about as these come through is, asking for more serious reforestation plans, which is something we have not been seeing a lot of, which would be, it's still not going to, do anything about the permanent right-of-way, but it could be something that, for example, if they did a well pad in a forested area and you forced them to find land where they could reforest, you could close up some of that edge effect potentially in other parts of the area.
Just to add to that, though, what Deborah just described is exactly what my job is. When we get a pipeline, we look to minimize those impacts. We don't go right through forests. We go on boundaries. We don't go right through ag fields. We cut on the boundaries of the ag fields. We avoid wetlands. Laser's a perfect example. If you look at the alignment of the laser line, we zigzagged up a hill so you couldn't see it from the highway. We skirted ag lands. In some cases, the final right-of-way is only 25 feet wide, exactly to minimize the kind of impact Deborah was just referring to. So I'm not saying there's no impacts, but I'm saying that I have a full-time crew whose only job is to look at these things and say, how do we minimize them to the greatest extent practical?
And that's why I'm saying to you, when your federal transmission lines come through, advocacy to adhere to the state standards would mean a major improvement, because the pipeline we're fighting in Pennsylvania is greenfield pipeline, and they mowed through 228,000 mature trees in forest in order to build this pipeline. And they are not reforesting 1 acre of it unless it's riparian buffer zone. So, what FERC will let these companies get away with is very different. But here in New York, where the standards are much higher and people aren't going to stand for this, you might have a chance, with some real political pressure and working with your agencies at the state level and putting your comments in to get much better mitigation measures.
And just to add one more cell is that even though some of the right-of-way easements are down to 25 feet, I still think it's very important as a municipality to consider those consultation zones, to allow the forestation to come back to that degree, but to not put a lot of structural human development that close to the pipeline. So to play with, let the environment come close and not the people, the people in the development.
We're going to take 2 more questions, a gentleman there, and then Sue Beener in the front, and then we'll wrap it up.
I have a 1A and 1B. My 1B is for Deborah. It's a yes or no question. And then my real question is for James. The question for Deborah.
Cross-examination.
The question for Deborah is, you mentioned on the intervention, the 30 days, it's almost impossible. Is there any kind of way to make a due process attack on that if there's no real way you can get the 30 days? James, your question I hope will be longer. The answer will be longer. What are the choke points, as it were, where if people want to attack these pipelines that you people administer, where do the companies, the applicants typically fall down that we can sort of most easily attack what they're trying to do?
I'll let you go first.
You got the yes, no, remember.
No.
I'd like to start my answer by saying I only got called James when I was in deep trouble at home, so I'm hoping that's not the case here. Our job, the commission's job is different than mine. The commission is to find need and to approve or disapprove the line. My job is to, as fairly and rigorously as possible, look at a project and decide, can it be done in a manner that minimizes environmental impact, that minimizes impact on the people around it. I said this at the end of my presentation, I'll say it again. and I'm always defending myself with DEC that somehow my people don't take their environmental stewardship at the same level other agencies do, and I reject that. I myself spent 15 years at DEC. That's my training. My staff are all environmental trained people and consider themselves environmentalists. If a project goes through, it's because my staff has reviewed it and said this is doable without really screwing up the environment.
Where are the first place these people fall down, when they fall down, if they fall down, where your office or somebody else's office says you better go back and redo this? Where are the weaknesses in the application process?
I rarely get an application that I don't suggest they supplement it. If you're asking me how to kill a project, I have to balance that with keeping the lights on and keeping the
heat
and keeping your stove and your furnace going in the winter. And there's a lot of places in New York that are not at critical levels, but a lot of people are converting to gas right now, and there's a reason for that. It's a clean fuel. It's better than oil. It's better than many other things. Well, okay, it's cleaner than other fuels. How about that?
It is cleaner. If we could please have the audience hold their comments. No. I think we have time for one last question.
I'm Sue Beaners from Town of Danby, and we have a gas ban, which I'm wondering if that would mean that we would be able to prohibit gathering lines if they were to suddenly start popping up in town. We'll find out about that. I guess, Jim, you were indicating that you didn't think that the unregulated gathering lines were going to be too much of an issue with Marcellus because they would be higher pressure.
Yes, absolutely, and longer than 1,000 feet.
Well, I guess what I'm wondering, and I'm not sure if it's maybe for each of you, is it worth local municipalities looking at regulating gathering lines to require environmental mitigation and also perhaps to require increased setbacks?
Well, two parts of that. If your town or municipality has to issue any permit at all, state law already requires, SEQR already requires that the environmental impacts be reviewed. An environmental assessment form, as Deborah pointed out, there's two levels. Environmental impact statement is the second part. Environmental assessment form is the first. So if you have to issue any permit at all, state law already requires that you do that you look at the environmental impact. As far as zoning or banning, I'm not sure if your town is the one that just had the court challenge and okay, I'm not an attorney, so the state says for projects that are Article 7 jurisdictional, the Public Service Commission has the jurisdiction over those. That doesn't mean you can't stick in a requirement that bans them. A person who wants to put a line in any way would have to show that ordinance is unnecessarily restrictive. They'd have to convince the commission of that.
And so do you feel that if, let's say, we did not choose to ban it, do you think that local municipalities can regulate location of gathering lines?
You can't supersede Article 7 for lines that are subject to Article 7.
For lines that are not subject to Article 7.
You can do anything you want.
I think the people that hold the power in that situation would be the people entering the lease agreement. They're the ones, the landowners are the ones that have that participation, and you may want to inform them. And you could still have a general plan within your community and guidelines about where you prefer the gathering lines to go, if you want them next to right-of-ways that are existing, et cetera, and so that your property owners in town could use that as they write their leases.
Yeah, with respect to the federal lines, you've been framing this in terms of gathering lines. The federal lines are, the local zoning is not going to control what the federal government is going to do. And it's not going to control what the state is going to do either, but the state is just more deferential to the local zoning. So, if I were, for example, if I were a lawyer, I would say that the argument that we're making with respect to the location of the well pads and the oil and gas development is a different argument when it comes to the pipelines.
I'm going to close tonight's program. I know there were lots of people that didn't have a chance to get their questions answered. I appreciate all the interest, and I especially appreciate our three speakers who did a great job in their presentations and also answering questions. So let's give them a last round of applause.